Community property in the state of Nevada is defined as all property acquired during the marriage, except for gifts, inheritances, and personal injury damages for pain and suffering. Both spouses are considered to have a present, existing, and equal interest in all community property acquired during the marriage. It belongs to both parties equally, regardless of whose name is on the paycheck. As of some years ago, Nevada moved from a presumptively equitable to presumptive equal division upon divorce. This is the analogy of the meat cleaver. The job of the lawyers in the court is to take all the property there is and put it on the table, and the court presumptively will chop it right down the middle. Now, there are some exceptions, based upon a couple of cases called Lofgren and Putterman, in the event of compelling circumstance to divide property unequally. A full explanation of the reasons why a court might choose to do so is set out on our website under Published Works, under Disproportionate Division. There's a couple of concepts that are important to know in terms of the acquisition of community property. They're called transmutation and commingling. Under the first, the property that's in one party's name can be turned into the property of the other party or into the property of both parties. And likewise, the property belonging to both parties can be turned into the property of one party or the other. This is called transmutation, transmuting, altering the title to property. An example would be where you took sole and separate property acquired before the marriage, and you consciously chose to deposit it into a jointly titled bank account. The law presumes that you intend to do that which you actually do. And because of that, if you take separate property and you put it into a jointly titled asset, the law will start with the presumption that you intended to make a gift of one half of your premarital separate property into the property of both parties. Commingling is when there are identifiable bits of both separate property and community property in the same place. The classic example is a bank account. Suppose that on the day you got married, you had $100 in the bank. And then after you got married, you got a paycheck and you put it into that account. And then you took some money out of the account and you put more money into the account. Well, if you ended up with $150 at the end of the day when you went to get divorced, it wouldn't be possible by looking at that money to say whether it was the original separate property, or it was the newer community property, or it was some combination. The test in Nevada is that if you can't tell, it belongs to both parties. If you can't tell whether property is separate or community, it's community. There are two possible ways to separate: direct tracing or exhaustion. Those tests are a little bit more complex and difficult to explain that can be gone into here. It is possible to have a community interest in a separate property asset. In the Malmquist case, a fellow was divorced twice. In the first divorce, he got the house. After he got married to the second wife, he never changed title to the house. It remained in the husband's separate name. But throughout the marriage, he took his income and he made mortgage payments, did landscaping, made improvements on the house, etc. So the question upon divorce in the second marriage was who actually owned what. The Supreme Court of Nevada came up with a couple of pages of algebra to trace the payments made on a separate property asset with community property funds, like a community property paycheck, during the marriage. Also, courts are empowered, but not required, to trace back to a separate property source contributions to property that's held in joint tenancy that came from a separate property source and order reimbursement to the contributing spouse. There are various factors, there are various rules. The factors recited in the statute are the intent of the party who placed the property into joint tenancy, the length of the marriage, and anything else the judge believes is relevant to determine whether or not the property should be traced back. But the burden is always on the party seeking to establish that there is a separate property interest in an asset that's titled in joint names. Under the law of Nevada, pension plans and retirement benefits are perfectly divisible, just like any other form of property. Nevada follows the time rule, by which the number of months of marriage during service is divided by the total number of months of total service, and that percentage is divided by 2. That percentage, whatever it is then multiplied by whatever the retirement benefit is, and that presumptively is the share going to the non-earning spouse. Now, normally, a spousal share is payable at first eligibility for retirement. That's a little bit unusual compared to some other states. It's the same rule as there is in California, and it means that the spouse might be entitled to payments even if the other party remains in employment. A full explanation of how different kinds of pensions are divided in Nevada is set out under Published Works on this website. There you'll find the results of our all-day seminar on the division of retirement benefits under Nevada law. discussing military, civil service, quadros, PERS benefits, and various other things. I would urge anybody with a problem like that to review all that information in detail. Normally, property adjudications are considered final upon divorce. There are some exceptions. Clerical errors can be corrected at any time under NRCP 60A. This probably includes all mathematical and typographical errors, but not judicial errors. Under NRCP 60B, the distribution of disclosed property can be changed due to fraud, mistake, etc., certainly within 6 months of the date of divorce, and possibly thereafter by independent action, filed more than 6 months after the entry of the decree, if it's based on certain kinds of actions that are considered fraud on the court. Again, a full explanation is in the CLE materials under published works that I referenced a minute ago. Additionally, a party can usually seek partition of an omitted, non-disclosed asset upon discovery at any time after the divorce. The case law, however, is somewhat contradictory at this time. The clear trend, however, of modern opinions is to consider the parties tenants in common of any asset not distributed at the time of the divorce decree, allowing a later suit for partition whenever the discovery is made. Debt is a little bit more difficult to be clear about. Under Nevada law, there is some indication in one published case called Wolf that debt is to be divided equally, but the mention was not spectacularly clear, and there is no true controlling statute. It is necessary for the parties to independently terminate their joint credit in order to stop the other party after divorce from running up credit that the creditor might then seek from the other party. The court's division of debt is not binding upon third parties. If the court said that the husband was to pay the MasterCard and the wife was to pay the Visa, and the parties didn't actually separate their credit, if one of them or the other ran out and ran up a huge credit bill on the other's credit card, then the creditor could choose to chase either party. That party would then have a right to go back to court seeking recovery from the party who was obligated to pay the amount in the first place. But that is a messy and not very economical way of satisfying the court's original intent. It could create a liability to the other spouse, however, even if the owing spouse declares bankruptcy. The family court maintains jurisdiction to enforce its orders as to debts, as it does regarding property.